This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
So the IPF, my lord, the petitioners. Well, this is, my lord, public interest litigation. My lord, it's a continuation of, my lord, the two previous rounds, my lord, in which, my lord, this honorable bench, my lord, was pleased to consider the
Nobody is
matter.
opposing you, Mr. Dotto.
But I think on the last occasion,
Somebody appeared, no?
Yes, yes, yes.
Mr. Mishra.
I think Mr. Mishra had appeared. Right.
This is next to the Advocate General. He would appear. Mishra.
Yes, I think, my lord, subject to correction, সেদিনই তো ডেটটা ফিক্স হয়েছিল হ্যাঁ
He would appear. Have you given a notice to the Advocate General?
No, I think, my lord, again subject to correction, recollection, he
Mishra appeared.
informed the court that the learned AG would be appearing.
Yes. Mr. Why don't you see if Mr. Mishra is there or not? Yes, Mr. Dotto.
Yes, ma'am. But only to, my lord, for your lordship's recollection only. But initially, my lord, the first writ petition, my lord, or the first batch of writ petitions, was, my lord, the challenging, my lord, the declaration of the OBC post 2009. Previous to 2009 or up to 2009, my lord, there were 66 classes which were declared. Now, my lord, post 2010, my lord, the declarations and, my lord, percentage of reservation for the OBCs and classification of OBC into A and B, my lord, fell for consideration before this honorable court. But the lordships were pleased to, my lord, retain the 66 which were declared prior to 2010, and, my lord, were pleased to set aside the declaration post 2010. Your lordships were also pleased to, my lord, declare some of the provisions of, my lord, the 2012 Act as ultra vires. Your lordship was pleased to interpret one of the provisions by saying where it is said the state government, it is not the state government in its executive capacity, it is the state government in the legislative field. And, my lord, your lordship was further, my lords were, my lord, further pleased to reserve the rights of the people who had got the benefit under the 2010 notification. These were, my lord, primarily, my lord, the findings of this honorable court. Then, my lord, it went up for challenge before the honorable Supreme Court. But the Supreme Court was pleased not to stay your lordship's orders. And at the same time, the state informed the Supreme Court that in terms of your lordship's order, my lord, a fresh exercise is being undertaken. That was noted by the honorable Supreme Court. Then, my lord, the fresh exercise was undertaken. Again, my lord, there were certain declarations. Again, my lord, there were classification into A and B. And, my lord, as per your lordship's previous direction, my lord, before the second declaration, my lord, the matter was placed before the Legislative Assembly. And then, my lord, it was declared. This declaration, post the 2024 judgment of your lordships, again fell for consideration before this bench. Then, my lord, your lordships were pleased to stay the operation of whatever was done after your lordship's order. So that order, my lord, went up for again, my lord, before the Supreme Court. The lordships of the Supreme Court was pleased to stay this order, the second interim order of your lordships. Then, my lord, the Supreme Court was insisting over two matters where there was a contempt proceeding. Certain orders were passed. The honorable Supreme Court again was pleased to stay the contempt proceeding. These are possibly not be of much importance today. Then, my lord, there is a change in the ruling dispensation in the state. But after the change of ruling dispensation, again, my lord, certain notifications have been issued, my lord, on 18th of May 2026, which are subject matter of the present writ petition. And the other development is that after there is a change in the ruling dispensation, now the state government has gone up before the Supreme Court and have withdrawn all the appeals which were pending before the Supreme Court. Therefore, today, my lord, as on today, my lord, nothing is pending before the Supreme Court. So what is existing today is, my lord, the final order of your lordships of 2024 in the first round. The second is, my lord, the second round. In the second round, the batch of writ petitions with the interim order is pending today, because since the SLP has been withdrawn, obviously the interim order is subsisting today. And the third would be what I have today come up before your lordships with. Now in this I mean the recollection of the trail of litigations, if my lords may now kindly take page number 88. Where three notifications are under challenge, where the first one is at page 88. This is notification number 944, dated 18th of May 2026. The governor is hereby pleased to withdraw with immediate effect the following notifications issued by this department, vide numbers 917, 1056, 1057, 1106 and 1107. With these which were stayed in the second round. Read with the corrigendum. But this is one. The next one, which is the subject matter of the present petition, is at page 89. Same date, it is 945, whereas the Honorable Division Bench of the High Court at Calcutta passed a judgment order on 22nd May 2024 in the matter of WPO, etc., wherein the 66 classes included in the state list of OBC prior to 2010 for the purpose of availing reservation under Article 16(4) of the Constitution were not interfered, and distribution of percentage of reservation as 10% for OBC A and 7% for OBC B were struck down. And whereas the Honorable Division Bench of the High Court at Calcutta also limited the reservation for OBCs in the state to 7% for the 66 classes in the state list of OBC unaffected classes. Now, therefore, the governor is pleased to inform accordingly that the state list of OBCs consists of 66 classes to avail 7% reservation in the services and post of the government of West Bengal. Then, the 66 classes which your lordships were pleased not to touch has been, those classes have been quoted. Then the third one is page number 92. This is the revised 100-point roster which was directed. You are requested, this is an interdepartmental communication. You are requested to revise the current model 100-point roster issued by the Labour Department, vide so and so, in line with the fresh notification referred to in 2, issued by this department in connection with reservation of so and so. Now, these are under challenge before my lords. Now, primarily.
So, Mr. Dott.
Yes, absolutely.
This notification which you are challenging,
yes,
this has done two things: brought down the reservation to 7% as per our judgment, and they have published the 66 classes
which were saved
as we are.
Yes.
Now then, this order appears to be in consonance with our judgment.
Yes,
appeal against which has been withdrawn.
Right. Right.
So, Mr. Dotto, at this stage, it is a bit premature because they have not said that we are withdrawing, our policy decision will be this, and we will not be incorporating any other class. That survey has also not started. So, at this stage, Mr. Dotto, what interference you call?
May I respectfully respond, Millard? The second notification, in my very respectful submission, was not required at all.
Page 89.
Yes, because without that notification also, whatever your lordships have held is holding the field.
Yes.
So, the second notification, for that matter, is was not at all necessary. But what
to
is
justify their policy decision that we are not going against the judgment, so they issued the notification 66 classes.
Yes, but so far as saving the 66 was never under challenge before the Supreme Court.
No, that we don't know what had been the challenge with the 66.
See, that we'll demonstrate, Millard. Yeah.
But at this stage, what intervention you want?
First is, so far as the first notification is concerned, which
page 88.
Yes. Now, whether Millard, what was the case in the second round? In the second round, Millard, the case was that the procedure which your lordships were pleased to lay down in the first round of litigation has been violated by the state. Therefore, Millard, your lordships were prima facie satisfied with the grievance and your lordships were pleased to stay. State, with the change of ruling dispensation, Millard, my respectful submission is where the Supreme Court has held in innumerable decisions that with the change of political dispensation, you cannot simply sit and review the earlier decisions. Unless Millard, there is some political involvement in it. Johar Himal and all cases made the lordships have been had the pleasure to Millard go through. Because after all, Millard, this is Millard dealing with fundamental rights. Article 15, Article 16 each are Millard what is under consideration in this field. Reservation emanates Millard vertically from Article 16, horizontally from Article 15. Therefore, Millard, when the state is prescribing for reservation, when the state is demarcating Millard OBCs, Millard, it is in fact Millard dealing with Millard Article 15, 16, read with Article 38 and 39 of the
But that stage has not come, Mr. Dotto.
I'm sorry, Millard.
That stage has not come
Yes,
yet.
that is the stage.
That this notification, if they publish further notification with or with the consent of the commission, then you can say, come and say that this exercise of theirs is derogatory because survey has not been properly conducted, etc., etc. But at this stage, what we will intervene, Mr. Dotto? Because you are saying these notifications referred in page 88, these were stayed by us.
Yes,
Supreme Court stayed our judgment.
Right.
Those things revived.
right.
Now, who will pursue that case on behalf of the state? State has changed its policy.
Yes, therefore, Millard, that was also a batch of public interest litigation. Today also, Millard, we are Millard before your lordship in a public interest litigation.
Challenging what? What you are challenging?
May I put it in this way? For the moment, Millard, please, we keep aside Millard what has happened on 18th of June. Let us keep aside that. All SLPs have been withdrawn from the Supreme Court, which means that Millard, the proceedings in the second round, there is no bar on the High Court to go into that veracity of those actions.
That we will consider as and when it is mentioned.
Now,
that challenge is always with you.
That challenge is always there.
That the withdrawal of the SLP, our order has revived.
Right.
Now you can, in that matter, it can be argued that there was a correct decision.
But that we cannot argue because today
we are not a party to this.
Not because of that, because those notifications are not surviving today. The notifications which were stayed, because a stay doesn't mean that your lordship will finally quash it.
No.
Your lordship may uphold that also.
No, Mr. Bhatto, notifications does not survive strictly because this stay has gone. So our stay over the notification is operating. It is only after writ petition was kept pending.
But today the situation is the writ petitions are pending. Second round. The interim order passed by your lordships were suspended for some time. Now it is reviving. The interim order is revived, legally speaking.
Now the issue is nobody is being given appointment on the basis of those circulars due to our stay.
Right.
In that you are not a party. That you may say that you cannot urge that issue before us. But when that process starts, that a fresh notification is issued, suppose incorporating upon a purported survey, they issue a notification for inclusion in the schedule which we have struck down. Then the cause of action arises, Mr. Dotto. At this stage, Mr. Dotto, what will you argue? The earlier petition which was moved before us, Mr. Dotto, point was taken that Supreme Court is in ceasing of the matter. You have gone through that order. In view thereof, primarily in view thereof, we said that we are not interfering. But Supreme Court, while passing that order of withdrawal of appeal, has made it clear that individual rights can always be agitated. by filing fresh proceedings. So you can, I think, subject to what you say and what my brother says, that
Third paragraph.
this appears to be a bit premature. Let that notification come, then you come and challenge before us.
Could I say this, my lord? First is, my lord, those notifications which has been withdrawn today, according to us, was in our favor.
Right.
Now, my lord, doing away with this notification definitely affects, my lord, the persons who were declared under those notifications which are challenged in the second
But
round.
that state, Mr. Dotto.
No, today it is not surviving.
Yes, we granted a stay in the context of that petition. We are saying in that we granted a stay, as you
Yes,
rightly said,
right.
it was suspended due to the Supreme Court. So they have withdrawn the appeal. The writ petition is before us.
Yes. Now the writ petition is before your lordship, challenging a notification which is not surviving. Today those notifications are not
What are
surviving.
you praying for here, Mr. Dotto?
My lord, here, my lord, if I succeed in demonstrating before your lordships that the 18th May 2026 notifications are bad,
Notifications withdrawing those earlier.
yes, then the earlier notifications will survive.
No, the earlier notifications issued post 2011 have already been struck down by us.
That is the
They
first
have
round.
gone.
First round.
Thereafter, the state issued fresh notifications, which we stayed,
Yes.
went to the Supreme Court, stayed, our order stayed.
Right.
Subsequently, SLP is withdrawn, the stay order goes,
Yes.
our order revives, but in one form, our order also and the writ petitions also become infructuous because the state has withdrawn the very basis of those writ
Right.
petitions.
Right.
Right?
Yes.
Now, what are you praying for? Your first argument, if we heard you correctly, was a change in political dispensation cannot ipso facto negate an earlier policy decision or earlier administrative order. That is your first argument.
Right.
That will have to be decided. We will decide that after calling for affidavits, if it. What are your other points in this? Please indicate that.
Yes. Well, my first point is well, what I have said. My second point is, well, we will demonstrate that, Millard, in the second round, the notifications that were published in the year 2025 were in tune with, Millard, the judgment of your lordships.
Very well. We have certain.
Yes, your lordships were by prima facie.
We will indicate that to you straight away. But please come to your next point.
Yes. Now, Millard, prima facie, Millard, your lordships were pleased to, Millard, come to the conclusion, that is why there was a stay, that no, your lordship's order was not followed
right.
in toto. Therefore, Millard, these are all prima facie, Millard, findings. Yes.
We will decide that.
Yes.
We will hear you
Yes.
out. What are you seeking today as an interim measure, if at all?
Yes. Now, Millard, interim measure, Millard, what I was, Millard, seeking is, Millard, if, Millard, these notifications are stayed, because, Millard, there are so many, Millard, fora, employment, academics, higher education, where, Millard, people have applied, Millard, in terms of the prevailing system. Now, what happens to those? Those, Millard, I think, Millard, calls for, Millard, some protection from this code.
Now, Mr. Dotto, coming to the second point that we wanted to answer, as we were just indicating earlier.
Right, Millard.
The primary ground on which we had orally indicated to you may not have found place in the order, if you remember in the arguments there on that day, was this, that the notifications were issued under the Commission Act and not under the 2013 Act.
12 Act. Anyway.
2012 Act.
Yes.
That's now. So, the foundational law for issuing notifications, even if they were valid constitutionally, which maybe the current dispensation could not have withdrawn.
Yes, ma'am.
And we are with you on that, assuming we are with you on that. Still, the legal and foundational and fundamental basis, the foundation of those notifications was not there. It wasn't issued under the 2012 Act. They were issued under the
93 Act.
93 Act.
Right.
93 Act does not provide for issuance of any notification for reservation. They were not even issued directly under 16(4) or 16 or whatever it is, which we had said in our judgment that once you have a legislation, you can't fall back on 16. That you can debate, you can argue, because that is our final holding, and we are bound by our own judgment.
Right.
That part is okay. Now, when the foundation of the notifications is in question, can you seek any benefit or any benefit derived thereunder? Can it be protected in law? Is what we want to ask you.
But my immediate Millard. But there is a prayer G, Millard.
Yes.
It's a long prayer. Pending disposal so and so implementation of the notification stated such and such of 18.5 and all consequential steps taken and or notification issued pursuant thereto, and direct the respondents to continue treating the members of the affected 74 communities as eligible OBC candidate in terms of the notification issued during the year 25, and further restrain the respondents from denying the reservation benefits, scholarship benefits, welfare benefits, admissions, counseling benefits, recruitment benefits, appointment or any consequential benefits to the members of the affected communities solely on the basis of the impugned notification, and further restrain the response for publishing, acting or giving effect to any admission list, counseling list, merit list, selection list or appointment list to the extent the same prejudicially affects the members of so and so.
That already stands protected because the contempt applications are still pending.
Yes. But
That 74 list which you argued on that
Yes.
day, some appointments allegedly were given or admissions were given. We said in our contempt measure that you are all things which are being done, we will be considered by us. Contempt is automatically survives again. But Mr. Dotto, how can we, if suppose today you are saying we have to pass an order that you continue to treat those 74 communities as eligible OBC. We have held against that in our parent order, against which appeal has gone.
Yes.
Can we now, being the same division bench, or division bench doesn't matter, same
Yes, yes,
and
yes.
same law which we have tried to lay down, can we today on this petition say that whatever we have said, but you protect the 74%, go on giving protection.
Well,
This, Mr.
yes.
Dotto.
May I respectfully submit, Millard? Number one is, Millard, the power of the state is
We do so more than
not disputed by the court. The court is of the view that you have exercised power under a statute which is not applicable. But to that, where my respectful response would be that even if, Millard, I have quoted a wrong provision, Millard, if the power is ultimately there, Millard, it cannot be faulted on a ground of wrong quotation or provision. This your lordships have held in innumerable
Oh,
judgments.
Mr. This is getting far-fetched. Now, this is far too much. This is where we are having serious difficulty in accepting your argument. We will let affidavits be filed. We will hear it out. We are not inclined to pass an interim order at this stage.
Please give me a
For three
moment.
reasons,
Yes.
at least,
I'm sorry.
we can clear straight away determine.
Yes.
Absence of competence. We said in our parent order, it has to be a legislation, not an executive order. Whereas, what has been done is something which is hybrid. It is brought in the legislature at the instance of the Backward Classes Commission Minister or Backward Classes Minister. It is tabled. There is the process of passing a legislation means that there is a process of passing a legislation. Then it is sent after the two houses pass it. It is sent to the governor and the governor ratifies it. Then the amendments are to be effected to the schedule of the 2012 Act. That would have been the proper procedure. We would have considered West to later. It wouldn't have called for interim order had this process been done. We would have considered at a later stage as to whether there was proper survey or not in respect to the new classes. That's a different issue altogether. But here, this hybrid process, whether it constitutes legislation and whether it has complied with our order is the first question. Second thing is, it has not come under the 2012 Act. It has not been under 16. 60, had you done it under 16, it would have been directly falling foul of our parent judgment. Anyway, good, bad, indifferent. Now, that is one part of it. You have declared these classes under the 93 Act. It's like saying, I am declaring these classes under the West Bengal Poultry Development Act. Now, after doing so, you cannot come around and say that no, I have the legislative competence, executive power. So what if I mention the wrong act? Very difficult to accept, not acceptable. Thirdly, what has happened is this. There is these benefits that you are seeking protection of were granted at a time when the list was pending, both before the High Court as well as the Supreme Court. The Supreme Court did not dismiss the writ petitions. It merely interfered with an interim order. Now, to what extent you could have granted benefits when the matter is being pending before the Supreme Court as well as this court is a big question mark, and we are of this clear view, prima facie, that you could not have granted any benefits to anybody under the notification stayed and partially revived by reason of the order of the Supreme Court. We can either dictate this now, or we can call for affidavits and have a comprehensive hearing.